Good evening to everyone, and thank you for joining us for our fourth Environmental Justice Rulemaking Stakeholder meeting. For those of you that I have not had the pleasure to meet, I am Olivia Glenn, our department's Deputy Commissioner for Environmental Justice and Equity. We are convened today to engage in focused stakeholder discussion on two specific aspects of the environmental justice law for rulemaking. The first is renewal and expansion conditions, and the second is compelling public interest. This is building on a platform of the passage of the environmental justice law, the nation's first, on September 18, 2020. This law does not go into effect until we adopt rules, and today's discussion is a continuation of the process that gets us to rule completion. If you missed our first meeting or any of our other topical discussions and need some of that context, you can find that information on our Office of Environmental Justice website at nj.gov/DEP/EJ. Please note that tonight's conversation is only one step of consistent points of engagement in our rulemaking. In that initial meeting, we spent a good deal of time defining environmental injustice and illuminating its manifestation. This is a part of our past narrative that we seek to remedy through this legislation. We go to the next slide, please. For those of you who need live caption for tonight's discussion, if you peruse the bar that's at the top of the screen, you'll see the three dots or ellipses there. And if you click on them, you'll get a drop-down menu. And one of the options, a little past the halfway point, is to turn on live captions. So please feel free to do that if you need it. And what you will see is that the captions will show up along the bottom of the Teams window. I will also note that, as usual, we are recording tonight's meeting and that this recording has already begun. And by joining tonight's meeting and sharing any public comments, either in writing or verbally, you are giving your consent that you're fine with being recorded for the purposes of this session. You can go to the next slide, please. So our agenda for tonight is to introduce the topic and discuss rules of engagement. Next, to talk about implementation, limitations, and a potential four-step process. 3, to talk about permit conditions. Next, to talk about compelling public interest. And as usual, we'll leave a lot of time at the end for questions and answers, but do also feel free, if you have an immediate question while we're presenting, just feel free to raise your hand and we will also take questions intermittently. To raise your hand, you will see across the bar at the top, there's a smiling emoji with a hand like this. And if you click on that emoji, you'll see a drop-down menu that has a hand showing a palm. And if you click on that button, that will demonstrate that you want your hand raised to be called on to give a verbal comment. So we welcome you to do that. The other option you have is to drop a comment in the chat. And that is the icon that is to the left of that emoji that looks like a comic strip speaking point. And you can just click on that and it will open up the chat thread where you can write a comment or ask a question. I will note that what we generally do is if we see a comment, we will acknowledge that we've received your comment and we will incorporate it into our consideration. But we want to focus tonight mostly on answering questions that people have because we want to be sure that we're giving all the clarity we can while we're on the line together this evening. In terms of next steps, we will have a future stakeholder meeting on May 6th, and the topic for that meeting will be environmental justice impact statements and the permitting process. We'll have a morning meeting with business and industry and an evening meeting with the environmental justice and community organizations. And The presentation, tonight's recording, and a follow-up survey will be available on the Office of Environmental Justice website, which is nj.gov/DEP/EJ. The next slide, please. For our rules of engagement, we want to ask for everyone to remain on mute unless speaking. And I know that when the call first started, we did a universal mute, but if you've come on since we've started, it's possible that you could be contributing some feedback. So make sure you mute yourself. We want to make sure we have a really good quality recording for the meeting and that we minimize the feedback. So thank you so much for your consideration of that. We already talked about the use of the raising hand function. We're going to ask everyone to treat everyone with respect and to limit your question or comment to the topic being discussed this evening. We want to limit the comments or questions that are asked to 2 minutes, and you will see me physically raise my hand like this once you approach 90 seconds, just so you know you have 30 seconds left. And again, for those of you who may have come on since I've said this previously, this meeting is being recorded and it will be posted on the DEP website once this session concludes. Next slide, please. So I know that we're about halfway through our stakeholder meetings for the rulemaking process, and I thought it was a good time to just revisit what our guiding principles are within the Department of Environmental Protection. These are our 5 principles. First, to follow the law. Second, to use the best available science. 3, to listen to all sides. 4, to find the best balance. And 5, to be transparent and honest with the public. So these are the principles that guide the work that we do within the department. And we're going to ask, as we have our discussion this evening, that we collectively share these guiding principles as we're all working together to do what we think is best for our overburdened communities in our great state.
Okay.
So in terms of topics that have been covered in past meetings, we've talked about geographic point of comparison, facility and permit definitions, and environmental and public health stressors. So if you have interest in those topics, I would encourage you to go to our Office of Environmental Justice website, and you can find our past recordings there. Today is conditions for renewal and expansion and compelling public interest. And looking ahead, we're going to talk about environmental justice impact statements and process in May, and then we're going to hold a summary and overview meeting in June. So please stay tuned for those. The next slide, please. Before we get into discussion that will be facilitated by my colleague, Sean Moriarty, who is our Chief Advisor for Regulatory Affairs at the department, I just want to talk about some of the limitations of the law. First, the bill does not, it's the law now, it's not a bill, so I will correct that. The law does not require absolute denial of environmental permits for new facilities. Second, the law does not allow DEP to deny facility expansions or permit renewals. 3, it requires an analysis of localized public health and environmental impacts and an analysis of additional controls that can be put in place to reduce localized pollution as conditions to any permit. And finally, this law is not effective until the adoption of regulations. Now, of course, we have to spell out these limitations, but we also know there is great opportunity, and that's what we want to spend some time talking about this evening. So without further ado, I'd like to hand this over to my esteemed colleague, Sean Moriarty, to continue our discussion. Thank you.
Thank you, Deputy Commissioner Glenn, and excuse me, good evening to everyone. And just to echo the Deputy Commissioner's points, thank you for joining us once again for what is now round 4 of our stakeholder process. Before we begin, I just want to again echo Olivia's points that we're really after an open dialogue today, and we just ask folks to not be shy about raising your hands at any point that you feel you'd like to weigh in on anything that we're talking about. I think today's presentation is going to be a bit less dense with slides, and we're really hoping for more discussion than necessarily running through 20 plus slides with a ton of information. This topic, or the two topics we're addressing today, expansion and renewal conditions, as well as compelling public interest, really do demand some back and forth. So I will certainly pause in places. We have slides that will tee up questions, but again, just encourage folks to jump in whenever you want, and feel free not to wait until we pause. So with each of these meetings, as we've been building up the rulemaking process from the beginning, I think we've tried to provide as much context as we're able to at each step. And I think at this point, somebody's not on mute. Sorry. Thank you. Sorry. We endeavor to provide some context to what we're talking about today. And I think that given that we're getting into more process-centric conversations, it's important to lay out, at least preliminarily and at a high level, what this process could end up looking like. Obviously, there will be many more nuances and many more kind of steps, but broadly, we've laid out four potential steps, just to give us a little bit of flavor for what we're talking about. So step one would be an initial screening process, and this is kind of builds on what we talked about with our geographic point of comparison, as well as our stressors conversation, as well as the department's ability to put out that map that lists all of the overburdened communities within the state. So using that map, that publicly available data mapping tool, along with the stressor layers that we would endeavor to put together, folks, applicants, members of the community, or otherwise will be able to determine whether an overburdened community is subject to disproportionate environmental and public health stressor levels when compared to the appropriate geographic point of comparison. Obviously, some decisions to be made there, but very generally, we would aim to have a publicly available and fairly objective way for folks to make that initial frontline determination about whether the stressor levels, as compared to that point of comparison, are higher than in the OBC, or higher than that geographic point of comparison. The second step is what we're terming kind of the disproportionate impact analysis. That would be through the environmental justice impact statement process, including the public hearing in the host community, which is key to this process. An applicant would analyze whether and how the proposed facility will cause or contribute to disproportionate stressor levels, and propose avoidance measures. If the applicant cannot avoid causing or contributing to those disproportionate impacts, to those stressor levels, a disproportionate impact is present. In those cases, you get into step 3 or 4, depending on the type of facility, if we're talking about an expansion or renewal, or whether we're talking about a new facility. And again, 3 and 4 are the two steps we're most likely to cover today. So in step 3, when we're talking about permit conditions, so facility expansions or Title V, or we're using kind of colloquially, but major source permit renewals, where necessary to avoid or minimize potential adverse impacts, the department would impose binding permit conditions concerning the construction and operation of the facility. For new facilities, and where a disproportionate impact is present, the department would deny that permit application unless the new facility will serve a compelling public interest in the community. Again, extremely important language there, in the community where it is to be located. If so, the department can similarly impose binding permit conditions on the construction and operation of the facility to protect public health and improve baseline environmental and public health stressors in the host community. I see we have a hand, so I'll pause here, give someone an opportunity to speak.
Yes, that's Melissa Miles. The floor is yours.
Thank you. Good evening. Hi. So I wanted to add a comment here on this slide, because it looks as if when first when we say step 1, step 2, step 3, it appears as if the permit conditions automatically follows the analysis, when it seems that it's actually either or, because the permit condition at this point is really just for expansions and renewals, right? Because if we're talking about a new facility, we're not getting to conditions at that point. We're going from the analysis to, if it can't be avoided, to looking at whether or not there's a compelling public interest, right? So what is step 4 would actually be step 3. And then if there is a compelling public interest, then the conditions are put onto the facility. So, this is I think it's a little bit confusing. I mean, not, some of the advocates, we've discussed this at length, and we agree that, the permit conditions for new facilities should be coming after, it being, if it's deemed to be a compelling public interest. And one of the worries that we have is that when we talk about it in this way, that facilities may see, sort of conditions as a way to become, to kind of gain that status of compelling public interest, when, we don't want to see businesses trying to sort of buy their way into compelling public interest by saying, oh, we can do, community works or projects, when really the facility is what needs to be, we need to get some sort of condition on the facility if it's deemed to be a compelling public interest. Does that make sense?
Yes, certainly does. Yeah, I mean, I think, step 3 and 4, I think, I guess that's just how my mind organized it, but I definitely see your point, Melissa, and I think you're right in terms of the way we're conceiving of this, in terms of where those conditions go. It's, it's potentially kind of a fork in the road, depending on what type of facility it is, and we're going to talk in more detail in terms of what what types of questions we have with regard to what might be eligible for a compelling public interest, and how we want your feedback today, and I think we've already started to get it on how the department should look at the compelling public interest standard, and what is and is not appropriate to include there. And we're going to ask a bunch of questions about that and continue to get that feedback. So thank you. So I think what's one of the through lines through these different steps is really the avoidance of impacts to stressors. And those are the environmental and public health stressors that we've talked about previously, most in depth at our last conversation, and the ones that are listed in the bill. So, there's a couple of different ways that the department can look at this in potentially both a permit conditions situation, a compelling public interest, or even as part of the disproportionate impact analysis. And I'll stress as we get into this that this is a whether question, and not necessarily, there's not been a decision made in terms of any of these particular concepts, but really a threshold question about whether any of them are appropriate to consider. We want to get feedback on that. But there's a couple different ways to get to that avoidance paradigm. One is just for the facility itself to avoid any impacts to stressors from its own operations. That's certainly one thing, and that's potentially the initial threshold question we would ask. Beyond that, other concepts that we want feedback on today are whether it's ever appropriate to require a facility, or for a facility to agree to provide reductions to like stressors from offsite sources within a host community. Similarly, requiring or agreeing to do reductions to other stressors from offsite sources in a host community. And lastly, either requiring or an applicant agreeing to deliver essentially a net environmental benefit that improves baseline environmental and public health stressors in the host community. The overarching goal of any of these is, again, to connect any of these measures to those specific stressors that the community is facing that are at disproportionate levels, and potentially to bring additional benefits or improvements to those baseline environmental and health conditions. So I think with that, we'll move on to the next slide and start to get into some of the more specific questions. So first and foremost, discussing permit conditions. Again, this applies to facility expansions as well as major source or Title V renewals. In those situations, and in all situations, we do go back to the statute to guide us. So we have just a brief recitation of what the statute provides here. It states that where a disproportionate impact exists, the department may apply conditions to a permit for the expansion of an existing facility or the renewal of an existing facility's major source permit concerning the construction and operation of the facility to protect public health. So that is our statutory charge, and we'll talk about a couple of different ways that we might be able to get there. Next slide, please. So I think the first question that language demands is that we make a determination about what constitutes a new facility versus an expanded facility versus a renewal. And that first question, kind of to frame the conversation for us, is how should the department differentiate between new facilities versus expanded facilities versus permit renewals? And we've listed, for the purposes of conversation and hopefully to give folks an idea of where it might be, an idea of what these things could look like. So a new facility could very simply be a newly sited facility, which seems pretty clear, or a change in use of an existing facility. So whether an existing covered facility or non-covered facility changes that use to be another covered facility that is different from the one that already exists. Expansion could be a facility requiring triggering a permit threshold for the expansion of its footprint of operations, or could be an increase in stressor contributions of the existing facility. And that could come from several different places. One thing to note here is the statute exempts minor modifications to major source permits for activities or improvements that do not increase emissions. So it essentially acts as a bit of a caveat or exemption to the broader expansion language. And then we have renewals, and I think we could be pretty straightforward in that. It could just be the continuation of existing operations as they are. One kind of ancillary question that comes from this is how the department should treat applications that reduce impacts. There's a couple ways to look at that, and a couple ways that facilities might propose those. One is a facility that proposes to increase pollution controls on direct emissions, whether it be air or point source water pollution, something like that, where they're seeking to let's say expand, but as part of that expansion, they're adding pollution controls that effectively will reduce their direct source emissions, even if they might be increasing their throughput or activities in some way. That is one aspect of it, but we also have in our minds what that means for the overall facility, and whether that includes increases in truck traffic, includes increases in stationary sources on the facility, increases other ways in which the facility might impact stressors, and we need to be able to deal with that. And we're looking for feedback on, where those lines are, whether it is ever appropriate to consider, an expansion that reduces stressor impacts as not requiring further analysis on the environmental justice law. For example, if that expansion were to reduce stressors across the board, or if it reduced stressors in one place while maintaining consistency of that in another place. That's certainly something that we're looking for some feedback here. I don't know if folks would like to weigh in on this, any of these questions right now.
Okay, Julia, the floor is yours. Make sure you unmute yourself. Julia Summers. There you go. Good evening. Your volume sounds a little low.
I'm sure I will use the wrong terminology, but if the community is identified as stressed, but the town wants a project and changes the zoning, even though there is opposition, how does that work?
Well, so the environmental justice law gives the department certain powers, and our permitting authority is separate and apart from local zoning and local zoning permit authority. So, if a municipality wishes to zone something in a particular way, that's certainly their right, but that doesn't compel the department to follow suit with issuing any of its permits under the environmental justice law if there is a finding of disproportionate impact. If we're talking about a new facility and there is not a finding of compelling public interest, then the department is not required to grant a permit that is follows or is consistent necessarily with that zoning determination. I mean, I think part of what we aim to do here, and part of what the bill really does point to, is giving a voice to folks in those specific overburdened communities and making sure that that voice is heard, so that the department and the applicants and everyone can understand the position of individuals in those communities who are affected by these overburdened stress levels in this permitting process.
So in this case, I'm thinking of residential to industrial. And truck traffic would be particularly, and all the associated burdens would be the impact. How does the neighborhood, clearly you can't get involved in the zoning, so at some point there will have to be an application that will come in. Is that when the community gets involved in commenting to the department?
Certainly. I mean, I think there would be a public hearing, there will be a comment process for any department applications, and we would certainly be directly involved in that, yes. And the community, we would be hearing from the community in those situations.
Thank you very much.
Absolutely.
Thank you, Julia. Next is Nancy Griffith.
Yes, I'm sorry, but I didn't really follow the question you just raised. Were you asked, well, it seemed you were saying, is it ever appropriate to consider an expansion as something if it reduces stressors? And I didn't get that.
Sure. So I guess the idea is if there's an existing facility in an overburdened community, and they are planning to increase operations, so increase their throughput in some fashion, and as part of that, they might require a permit modification. That permit modification might be submitted, and that permit modification could include the addition of pollution controls that would upgrade or update their pollution control apparatus at the facility. And the result of those upgrades, even though there might be additional throughput, is a reduction in their direct emissions. And then I think what we're talking about and asking about is how do folks feel about that type of application, and whether it belongs in a more robust environmental justice analysis. And then kind of some of the nuances there are if they increase throughput that and reduce direct emissions, but in some way leave their indirect stressor contributions like mobile sources flat, or they do increase, is that something that the department should be looking at as a renewal? As an expansion. I think that's kind of the way we were trying to frame it. Apologize if it was not clear.
Versus not considering it as an expansion?
Correct.
Okay. Thank you, Nancy. Next is Dr. Nikki Sheets. So Nikki, I'm not sure if you put your hand down, if you meant to do that. Just want to give you an opportunity. Oh, there you go. Okay.
Talk about this question, and I'm sorry, you're going to hear from a lot of us later too, and we talk specifically about compelling public interest. But, on this question, I would say, and good question, we hadn't really talked about this, so this is just coming from me now, that it should be considered an expansion, that you certainly should take into account indirect emissions. And if you do the analysis and you find that emissions do go down because of the pollution controls put on, that you should make those conditions of the permit. So, and that would give you, considering expansion, would allow you to do that. So that then, you lock in those, whatever equipment, whatever made the emissions go down, then you should lock those in through conditions of the permit. Another thing I was going to say that may be a little bit nitpicky, but I saw in your slides before, the law does not say disproportionate impact. Right? The law says that if granting a permit will cause, adverse cumulative health and public health stressors to be higher in that census block group or in that overburdened neighborhood than the other ones. And I think, and I saw your definition of what disproportionate means, which is pretty good, I think. I like to think about it more. But I think how you talk about that makes a difference, because I think when I hear disproportionate, that to me sounds like a higher standard, a more difficult standard to meet than if the cumulative stressors would just be higher in the census block group in question than other block groups.
That's fair, Nikki. I understand what you're saying. I mean, I am meaning it the way you're saying it. I'm meaning it as a way to term higher, but your point's well taken.
Yeah, and I kind of like your definition of that, but I think it's cleaner, you know, because I think once you start talking about disproportion, then people may start weighing in, well, you know, here's what we mean by it. This is what you should mean by it. Whereas I think higher is a little bit cleaner and more straightforward.
That's fair. That's fair. I've been using disproportionate so much that I guess I've adopted it as lexicon as if it is in the bill. But higher than is certainly the language there, and that's what we intend. So thank you. And always happy for you to pick our nits when we don't get it right. So it's appreciated.
Okay.
Yeah. Okay. All right. We can go on to the next slide. Okay. So we've talked about whether a particular application should be considered new, expanded, or whether it falls in the category of renewal. Now we would talk about how should the department approach the application of conditions on the construction operations of those facilities, particularly expanded facilities or Title V renewals to protect public health. We have a series of questions here. I'll walk through them and try to give a little bit of context to those questions and certainly invite feedback. So, the first question is, should avoidance and, if not feasible, minimization of the facility's contributions to disproportionate stressors or be a standard condition that the department imposes? And in the context of a Title V renewal, certain things that we've been thinking about internally are, should the department impose or seek to impose kind of a best available control technology, which is kind of a federal term, or a state-of-the-art technology standard, which is more of the state term, on those Title V renewals as something resembling an objective or at least understood standard that at least the direct emissions from these facilities would seek to meet when they come in for renewal. And kind of building off of that, and the sub question is if we were to impose that, should it be imposed every 5 years, which is kind of the standard renewal timeframe, or would it all be appropriate to impose that on a longer basis, every other renewal, for example, 10 years or something like that? Additionally, where facility contributions can't be avoided, and this again in the context of a renewal or an expansion, should the department consider additional measures to improve baseline environmental or public health stressors in the host community? And this gets back to some of those concepts we discussed earlier, and that would be like reductions to like stressors from offsite sources in the host community, reductions to other stressors from offsite sources in the host community, or even requiring an applicant to deliver a net environmental benefit that improves baseline environmental or public health stressors in the community. Are these concepts that make sense in the context of conditioning a renewal or expansion? And if so, how should we apply them? Should they be applied in some sort of hierarchy, such that a facility be required to kind of work through them on a feasibility analysis basis or something along those lines? And then when we're looking at measures to reduce stressors elsewhere in the community, for example, should the department consider reductions to stressors in order from their highest to lowest contributors? So, if you were to take that publicly available information and kind of break down the individual stressor levels in an overburdened community, would it be smart for the department to ask an applicant for anything that is non-like kind to work from kind of those highest stressor levels to something that's lower? So those are kind of the questions to tee up this part of the conversation. Would love to hear from folks on this.
Kim Gaddy, the floor is yours.
Thank you. I guess when I'm looking at this new and expansion versus renewal, you have an existing permit, and to me, that existing permit, if you're going to have any changes, then that should be considered renewal or expansion. I think that is kind of confusing to have this either or, because you have an existing permit with no changes, or you have a renewal or of a permit that is considered expansion or new. So I'm just, to me, it seems like the language that should be employed here is that if there is changes to it, that is a renewal or an expansion, right?
Yeah, I think yeah, I think what we were trying to get at is if it's a renewal, we were thinking that is potentially just a continuation of that existing permit, like you're talking about, Kim. I think what we were talking about is potentially in the expansion context, if you're making changes to that permit, should that be considered expansion? I think that's what we were putting forth as kind of the straw proposal, trying to to keep those renewals pretty narrow in terms of just if you're going to continue to operate, that's a renewal, and if it's a Title V permit, we have an opportunity to review your operations at the time of that renewal. If you're renewing another permit, the bill does not give us the authority to address, say, a solid waste permit if it's just being renewed. But if they're changing anything, if that is considered an expansion, then we would potentially have the ability to review that and put additional conditions on their operations. I think that's where we were trying to get to.
Right. So that's what I'm saying, because then it should be expansion or new, right? Because that's what it is. Either you're expanding or you're getting a new one. But I guess the way that it's laid out seems to be a little bit confusing to me.
Okay.
Thank you, Kim. Next, we have Maria. The floor is yours.
Thank you. And I'm with Kim. It is a little, I'm a little confused about what you're asking of us, Sean, on this slide, but I'm gonna try, because one thing I just want to highlight that I really care about when it comes to renewals or expansion is that renewals, you're going to place conditions on them. I care about enforceability and consequences, because obviously what we've seen in the Ironbound is just a lack of consequences, that if there are conditions at all. So I think, where I see like every 5 years should a best available technology standard be imposed, I wonder, I just try to think how we could have prevented what the situation we have in the Ironbound, right? Like if Covanta had that, the best available technology, even in the 90s, was the baghouse that they didn't put for another 20 years. They didn't put it, they didn't complete construction until 2014, 2015. I forget the date, but that could have been avoided, I think, by best available control technology. And I think as technology is accelerating, even 5 years, things might become outdated. The only thing I will stress that I think is coming up for us as we're looking over permits is this 99.999% effectiveness. And I think that there should be a margin of error that is calculated for, right? And I think that we see facilities try to become like minor source because of that discrepancy. And what happens if their technology fails? Let's just say 0.1%. Does that push them into major source? And I think that needs to affect how I don't know that that's right in line, but I'm just saying that I think that it affects how the department should look at it. And that includes in conditions, right? Like if you're saying your technology is that effective, what is the condition you're placing should they fail? Should they start racking up violations when their technology doesn't meet that standard, And especially if they're developing a pattern. I really care in terms of what conditions you're going to apply about consequences. Because it feels like there are no consequences for hurting us. And I really feel like sometimes industry would have to kill someone's child to be denied a permit, to be, for a permit to be taken away. So what I want with the conditions is for there to be some accountability built in that doesn't require 2 and 3 years of litigation or settlement negotiations between the DEP and the industry. I want it to be kind of laid out. It's the alternative that we use with police. Right, that we want a discipline matrix. If you do that, then this happens. I would like the same for the DEP as you're protecting Black and brown life, that if industry does X, this is what will happen. And it's laid out, it's unequivocal, and it's clear for all of us to see. That's what I would say about permit conditions. And of course, if they're expanding their capacity in any way, regardless of admissions, if the inputs are expanding, then it should be considered an expansion. Like, I hope that gets at it, but those are my thoughts on the permit conditions.
Thank you, Maria.
Thank you for that. Next, Dave Pringle.
Hi, everyone. I'm really concerned with the framing here. I know we have to talk about conditions and compelling public interest, but I think it's important to remember and have all of this in conversation entirely be guided by the fact that before we're talking about any of this, the department has already determined this is an overburdened community. It's gotten more than its fair share of pollution and waste and health consequences, et cetera. And the permit at hand is going to make things worse. You've already determined those two things before you're talking about compelling public interest and conditions. And it was very clear the intent of the legislature was for you to be as strict as possible. Because with the exception of the Title V permit renewals, nothing in this bill reduces environmental racism. Everything in this bill just makes it not make it worse. So you really need to be extremely strict here. And I'll just provide two specific examples in the conversation here. Anything that isn't identical is not a renewal. When I get if I have my driver's license and it's current and I apply for a renewal, that's a renewal. If my driver's license was expired or it was suspended or I never had one, or I have a regular driver's license and I'm seeking a commercial driver's license. Those are news and expansions, and you should be given that renewals is the only place where we can make things better in here, you really need to be very strict with that. I'll just leave it at that for now.
Thanks, Dave. I mean, I understand your point. I mean, I think that part of what we're trying to get at here, and when we're talking about, in addition to as part of this renewal or expansion conversation, is talking about whether it's appropriate to ask facilities to do more than just minimize their own emissions. And I think that, I shouldn't say emissions, their own contributions. And I think that if we take a broader view of that, potentially, we may be able, through the renewal or through the expansion conversation, to be able to improve situations. And really, that's what we are making every effort to do here, and that's ultimately what we hope the rules.
And in doing so, you're already acknowledging that things are going to be worse than they are today. Minimized doesn't mean you're making things better. It means you're making them less worse.
Well, right now we're talking about in the context of renewals or expansions where we don't have the ability to deny those permits. So we're trying to work through a conversation about whether there are ways to improve conditions through that. And yes, we will discuss these same concepts as part of compelling public interest because we need to get feedback on that. And understand that you're already talking about that, and that's fine. And I understand people are not all going to agree with even having the conversation. But we do have to have the conversation so we can solicit that feedback. And if the feedback is negative, the feedback will be negative and we'll take it and consider it. Completely understood.
Thank you, Dave. Next is Amy Goldsmith.
Yeah, hi. I'm looking at this slide and we've had this conversation quite a bit about, mitigation off-site. And I notice you have here on your slide a number of sort of off-site sources to require reductions, and makes me nervous. I appreciate you saying within the host community, and you say that several places, and I appreciate your saying that, so that we're really talking about it very nearby or the impacted community, as opposed to sort of regionalizing benefits like building a wetland. And this isn't the right example, but you understand my point. Building a wetland in Monmouth County when the damage and destruction is in Newark, right? So I appreciate your saying within the host community, but we're really talking about the facility itself and the facility doing right and reducing pollution and reducing impacts, and it can't just like go off site and plant a few trees somewhere. It actually has to have reductions, and it actually has to do better. And in some cases, maybe it shouldn't exist. So I just felt kind of compelled. You have this language about net environmental benefit, and stressors off-site. It's not completely in line with what the law is, which is, it has to be within the community, and it has to be the benefit of the community, and it's related to the use and the operation of that facility. You can't kind of go down the street and ask Joe at the scrapyard to do better. You should be doing a permit on Joe the scrapyard regardless of this other facility that you're talking about under the environmental justice law. Thank you.
Thank you, Amy. I'll just, when we're trying to walk through this, again, for situations where we don't have the ability to deny those permits, we're talking about as a threshold, asking facilities or requiring facilities to minimize their contributions to the maximum extent they can. What we're trying to get to in this particular part of the conversation is whether we should be going further than that. And going further than that would require potentially actions to be taken off-site because the facility would have already done everything it can. So if we are going to attempt to get tangible benefits in the community, and we're talking about real tangible benefits, and we're not just saying in the community, now that's what the law requires, and we fully intend to meet the intent of the law to the maximum extent we can. And in the community is a key part of that. That's why it's here as many times as it is, and that's why we're emphasizing it as much as we can. There's no interest in regionalization of any of this. This is, again, real tangible benefits in the community, and we're trying to figure out whether there are ways through this particular part of the paradigm to deliver that beyond just minimizing additional impacts. That's not the goal.
Thank you. So I just want to interject that there are two hands that are raised right now. We will take these two hands, but then I think it's really important for us to advance through the presentation. And of course, we will take more questions on these previous topics at the end if there are still pending questions or concerns out there. So we'll take Ray Nichols, Julia Summers, and then we're going to move forward. So Ray, the floor is yours.
Thank you. First, a technical observation. The last line or two of your screenshot is invisible because of something that Microsoft Teams is imposing on my screen. Can I move that so I can read the last line? I could read 3 requires under examples, but I can tell there's something below that, but I can't read it. Can that get fixed? It's a technical issue.
Yeah, we did take a look at that as a technical concern because we did hear it from someone else as well. But unfortunately, we are not able to do that. What will be available is that once this meeting concludes, we will provide the presentation as well as the recording of our conversation tonight. So in both of those, you should be able to see everything there clearly. And we're sorry that we don't have anything else we can do about that that's impacting some people at this time.
Ray, just for your benefit, I mean, the last line, what we're talking about is if we're looking at measures to reduce stressors elsewhere in the community, again, going from on-site to some sort of off-site reductions in the context of a renewal or expansion. We're asking whether we should be essentially asking facilities to look at stressors in their order of magnitude in a particular overburdened community. So from highest to lowest, is that something that would be appropriate? That's what that last line says, if that's helpful.
That helps. I'd like to reiterate Amy Goldsmith's observation from the freshwater wetlands law mitigation. It's supposed to occur within the same watershed, same mini watershed, but we've seen it go from the Atlantic Basin to the Delaware River and vice versa. I think it's very important if you interject one more word when you say host community, and that is the host overburdened community. That may be implicit in your thinking, but it should be made explicit.
It is, and that's understood. Thank you, Ray.
Secondly, with regard to best available control technology and state-of-the-art standards, I assume that is imposed every time a permit is renewed. It should certainly be imposed every time a permit in an overburdened community is renewed. And the concurrent thing is DEP over the years has had variations in the effort put into enforcement of existing regulations. And I'm curious whether best available technology at this point in time, or state of the art, would allow for permanent recording of emissions going out a stack. I know that with USGS monitoring stream conditions, they can do that. I hope that could be done, if not now, in the near future with air emissions. That's it. Thank you.
Thank you, Rick.
Thank you. Julia, you're next.
Thank you very much. Amy gave an absolutely perfect example, because with wetlands, we saw when there were headwaters impacts, the mitigation was happening down at the lowest parts of the watershed. Maybe, I mean, the issue really is about the definition of the word community. I think community is being used to mean the municipality. Maybe we should be talking about the immediately impacted community. I think of the example of a community like Jersey City, which is a big town, and we could be doing mitigation in one part of Jersey City that has nothing to do with the area that has been impacted, and the immediate community is not helped by the mitigation. So maybe there should be a couple of clarifying words in there.
Sure, and I'll clarify right now. We're talking about the overburdened community. We're talking about the block group where the facility is seeking where the facility exists, or as we would talk about in compelling public interest, where it is seeking to be located. So we are talking about a census block group. That is the definition that we'd be using for community, and consistent with what the environmental justice law provides for us. So we wouldn't be looking at municipality, and we're certainly not looking at watershed or anything else of that like, if we're considering offsite reductions.
Is a census block small enough, in your opinion?
Well,
I recognize it's done by population, but
it's what the law has provided us to work with. It's how the law keys our assessment of whether stressors in communities are higher than those of their neighbors. So, that's at least what we were looking at using. Yeah.
Okay. Well, immediately impacted might be useful language.
Thank you.
Thanks.
All right. Now on to compelling public interest. I think we've already gotten some feedback on that. I anticipate we'll get more of the same as we walk through here. So again, back to the statute, back to kind of the core principles that we've been following and trying to follow the law. So the statute provides that where disproportionate impact exists, the department shall deny a permit for a new facility except where the department determines that a new facility will serve a compelling public interest in the community. Again, community meaning that overburdened block group where it is located. The department may grant a permit that imposes conditions on the construction operation of the facility to protect public health. So we're going to get into a conversation. We're going to talk a little bit about how the department should approach compelling public interest, and I anticipate some really good, robust feedback on that. Next slide, please. So the first question is very broad framing question, and really just asks how we should consider whether a facility serves a compelling public interest in that community where it is proposed to be located. And some of the sub questions we're asking ourselves and asking you here is, should the department require a consideration of alternatives to siting an overburdened community? And that could include alternatives in design that could be less impactful. It could include alternatives in operations that could be less impactful. Essentially, kind of asking a facility if it's seeking a compelling public interest finding, why it needs to be operated in that overburdened community, and what it can do at the very front end in its design to minimize impacts. We'd also ask whether there are specific projects that should be considered in a compelling public interest analysis. If there are things that, in the view of folks, are appropriate for consideration, and conversely, are there specific types of projects that should simply not be considered in a compelling public interest analysis? And that could include any of the number of facilities that are listed in the bill, as well as certainly a plethora of things that could potentially fall under the major source provision of the environmental justice law. So we're really kind of asking for some general feedback here. One, on alternatives, and two, on yes or no calls on specific types of facilities. Are there things that you think are appropriate for that analysis? Are there things that you think are completely inappropriate for the analysis? We'd like to talk about that first.
Okay, Maria, the floor is yours.
Yeah, it seems like we're being shy. Funny, right? I was waiting for someone else to jump in. I want to take up too much space. But it's obvious, like when we're talking about compelling public interest, to me, that it needs to be as narrow as humanly possible. Because under this guise of compelling public interest is how our communities have been sacrificed. Like that's the history that got us here, is that for the greater good, Newark had to bear the brunt for the greater good with PVSC, for the greater good with the incinerator, for the greater good of the power plants. And you know what? Maybe they plant some trees, so like that's to that point, alternatives in design are not to be part of the compelling public interest equation at all. It's only after we determine that there's a compelling public interest that we even get into the conversation about alternatives in design or conditions that might make, if for some weird reason, we find that something so compelling, we must have it, and we must have it on this historically disadvantaged, overburdened community. If we find that it's compelling, then we can consider conditions and alternatives in terms of operations, So, yeah, so that's, I think, really important, right? Like any conditions, that comes after the fact, not before. Because if you roll them in, I worry that industry will just try to package its way to become compelling. And to that point, it's not about the conditions, it's about the use of the facility. So how is the use going to be good for the community? The only thing I could possibly think of that might be compelling is a composting facility. And even there, it would have to be municipal in scale, not regional. It would have to, we have to determine the scale of said facility and in order to consider its benefits to our community, I just think we need to be the most careful with compelling public interest, that it has to be narrow. So when you're saying types of projects that should not be considered, I almost don't want to list them because I would be afraid to box in, something that we can't conceive of that they create in the future. Or as we're seeing right now with the sludge facility in Newark, they tried to change a word, instead of calling it sludge, they want to call it biosolids. And they think they could skirt the prohibition of sludge processing facilities, So I think industry will get tricky and slippery on us. I absolutely don't want to see that. And I think for everyone else listening, if they want to align for environmental justice with environmental justice communities, that they need to be clear that compelling public interest for us has to be narrow and actually has to benefit the directly impacted community. I'm glad to hear that, but we need to keep that up because the law was intended to stop the harm, stop the hemorrhaging in our community, stop the bleeding by being able to give the DP the power to say no finally. So I don't want to widen this hole. It is a loophole, but it needs to keep really tiny, not become something that swallows the rule. So I'll leave it there.
Thank you, Maria.
Thank you. And Dr. Sheets, you're next.
Yeah, thank you. I just want to, I think Maria hit the essence of it. Let me just add a little bit more. I was actually waiting for you to say a couple of other things that I've heard kind of tacked onto this, Sean. Maybe I'll address them anyway. Yeah, I think the way to approach this is that Maria gave one example of what might be, publicly. I think the way to approach this is to think of what could be a compelling public interest, and be as specific as possible, and then nothing else can be. If it doesn't fall in that category, if it's not that specific use, it cannot be considered for a compelling public interest. And even those things that fall into the category or specific definition, then you should still ask some more questions. And I know we kind of had this, I know I've heard discussion before about where should community input be here. This is where the community input should be if the facility possibly falls under a category specific definition that could be a compelling public interest. Then the community would have to also agree with it. Now, if it's not one of those uses, though, then no, then you don't get community input on that. It's just gone, right? No compelling public interest. And again, if it's not one of those uses, no balancing act, right? No net, does this facility have a net benefit? No. If it's not under one of those defined categories or uses, no, none of that gets considered. Now, if you want to add a balancing act onto that narrow category, well, let's talk, because then you're restricting that even further. But Sean, and Olivia, this strikes fear in the heart of all EJ advocates, right? This compelling public interest, and that it might swallow up the entire law. And I think I think what I'm suggesting here, and what Maria suggested, the very narrow definition legally of what a compelling public interest is, I think is consistent with what we recall is the legislative history of the law. And I'll just say what I recall is that we were really talking about very narrow things like public water work, public infrastructure, and really not anything else. So I would argue to you that this approach is consistent with what was intended when we were going back and forth at the time we were constructing the law about compelling public interest.
Nikki, thank you so much. I think you've given me some more clarity on this, and I think there's a question. Excuse me, a question of even some of the things that I assume perhaps don't communicate as accurately as I should. The threshold here is a definition of compelling public interest that is narrow. It is, and what we would aim to do here is to put as many specifics as possible to that, and I think to try to be in line with what you've suggested. So when we're talking about some of these other concepts, we're not talking about an open-ended definition that then just allows folks to propose net benefits. We are talking about something more narrow, and then whether there is a way within that type of definition to bring additional benefits to a community. So I really appreciate the way you frame that, and I really appreciate your ability to kind of open my eyes to perhaps some of the things that I haven't quite hit as well as I should have. So thank you again.
Thank you. Next, we have Ray Nichols.
Thank you. The key word here in many ways is public, and I've seen public interest defined as infrastructure or construction of something that is declared in public interest, but is really for the benefit of a private developer. And so I think that one way of narrowing the definition of compelling public interest is that it's planned, constructed, and operated by a public entity. It might be an MUA, it might be a municipality, but it might be a sewage authority, but it is operated by a public entity, a governmental entity of some form. Anything that is being proposed by a for-profit entity is automatically excluded. Too many municipalities have used the public interest, meaning a reduction in taxes for the average resident, rather as an excuse or a reason to justify private development. And part of what we're talking about here is public impacts on a local community, and DEP has an opportunity to define public narrowly. Okay? My time? Thank you.
You can certainly finish your thought. You have another 30 seconds, but
Oh,
the
thank you.
hands for 90 seconds.
Yeah. I'm thinking of sewage treatment plants and pump stations. Both serve to remove sewage from a community or an area. A pump station has much less of a impact on the local community than a sewage treatment plant. And so that ought to be taken into consideration. So among alternatives, the pump station would be preferable to a sewage treatment plant.
Thank you, Ray.
Thank you so much. And next is Marcus Sibley.
Good evening. Thank you so much. I just want to pretty much piggyback off what people were saying about the importance of narrowing this definition. And I also wanted to just add this, since George Floyd situation, there's so many more people who are paying attention. And I think it's really important that as we move forward with these types of endeavors, I think we have to be very clear with the language, as many people have pointed out. Many people tonight have pointed out different words that need to be used. I just want to make sure that those things are being added because what many of us, we interact with polluters on a daily basis, and they bring their very high-powered lawyers and they feast on language. So I think it's very important for us to be very, very clear with everything that we're saying. Nothing should be implied. Everything has to be in black and white and written down. And the other part I think is very important is, since we have so many people watching us, when we're speaking about the concept of public, so often the true public opinion is overlooked. And we have so many people who feel like they don't want to get into this fight because they don't feel that their voices even matter. And I think it's very important that when we say things like public, or even when we have entities saying we had a community event, we have the public interest at heart, just to echo what everyone else has been saying, very rarely is that ever reflective of the actual community where these things are taking place. So I don't know exactly what that is or what that should be, but I think our metric of how we measure what the public interest, we have to get a lot more clear with that, because I've seen on far too many occasions where someone met with someone that they're paying off, and we do an Oprah request and we learn that they're being paid off and they're getting money in some type of way, and then that counts as the public's interest in what's happening, or that counts as the community input. I think we have to really be targeted with our efforts on this. And the last thing I would like to say is kind of piggybacking off something said earlier, we have to be very serious about the consequences, because people are watching now, and people feel like a lot of these industries, they're always going to find a loophole, and they're taking calculated risk every time they do anything, and they don't care about the harm that's happening from a pollution and a health standpoint. They just know, I'm going to make 30 times more than what this fine is. So I think we have to be a lot more clever when it comes to the penalties, because the penalties have to be a deterrent. So I think those are things that are very important. And thank you for the opportunity to say a few words.
Absolutely. Thank you, Marcus, for your input. It's always welcome and really wonderful. Yeah. So I was convinced that by people that my slides were too busy. But a lot of what we're talking about, I originally had all on one slide because I kind of understood that folks would want to talk about community engagement, some of these other things. So community engagement is one of the upcoming slides, and we want to really talk about that as well. How we do accurately gauge the voice and input of that host community, of that host overburdened community, to make sure that we are giving a voice to people who have been overlooked, because we recognize that is one of the major keys of this bill, is making sure that participation occurs, and that the department has a clear understanding of what people in the community are concerned about and what they want to see in any of these given projects. So that happens to be our last slide. So I will just I'll just put a pin in that, because I want to hear more about that to the extent people have more to offer. Okay, so let's take this slide in the vein that Dr. Sheets laid out. where we have a very narrow definition with specific categories that we all can at least somewhat agree on, that is narrow and specific as to what types of facilities might work here in a compelling public interest analysis. And with, these are public facilities that provide benefits to the community. I think the question that we ask ourselves then is there more that we can get as part of that definition for compelling public interest? Are there additional conditions? Are there additional things that facilities can do that are seeking to be sought or seeking to be cited in an overburdened community that might have impacts, but are deemed by individuals in that overburdened community to be something that they would like to see? What types of conditions can the department consider that go potentially to offsite conditions, where those impacts cannot be completely avoided, but there is a reason why that facility is desired in that community. So it really gets us into the kind of bottom three things we're talking about here. I mean, I think when we talk about whether the facility itself should serve a compelling public interest, I think that's what we're getting at. I think that's what Dr. Sheets and Maria and other folks have advocated for. And I think that we've heard that loud and clear. So kind of moving on to that second part, in a situation where we have a narrow definition, where that facility would meet that narrow definition, would it be appropriate to consider additional measures? Would it be appropriate to oppose additional measures on that facility to improve those baseline environmental and public health stressors in the host overburdened community? And that again, when we were talking about with renewals and expansions, is it appropriate to ask for or look for a reduction of like stressors from offsite sources, other stressors from offsite sources, or things that are considered net environmental benefit to improve baseline conditions, such as addressing a lack of environmental benefits in a given community. And these all again, we would work to and ensure that they are connected to the specific stressors that we're tracking, so that we're not looking at things that are completely open-ended, but really drilling down on the things that are of concern and of interest from a stressor analysis point of view in a community. So it's certainly hopeful to get some feedback on that with those appropriate stipulations.
Okay, Dave, the floor is yours. Dave Pringle. Make sure you unmute yourself.
Sorry about that. I actually had my hand raised from the previous slide, so I'm not going to directly answer the questions on this slide. But I think it's important to remember that the DEP doesn't give up the right, even if you do conclude there's a compelling public interest, you don't give up the right to deny the permit. It doesn't say you shall approve a permit and you can apply conditions. It says you may grant a permit that imposes conditions. It's giving you the authority to impose those conditions. So obviously, if we've concluded it is of compelling public interest, we want that, presumably we want that facility to move forward, but there's no reason you can't, I don't know what the official definition would be in court, but if you're not acting arbitrarily and capriciously, you could impose a whole heck of a lot of conditions, and you should, because you've already concluded, even though we want this facility, you've already concluded it's an overburdened community and it's going to make things worse.
Thank you, Dave.
Thank you. Next, we have Elizabeth Limbrick.
Hi, thank you. And just thinking through this particular slide and talking about, if there were offsite sources that you wanted to look at that could be minimized, I was thinking if you go back to one of the previous discussions, not from tonight, but from one of the previous discussions that you had for this rulemaking, and you looked at what the stressors are in the community that make a community overburdened, I think tying those two together would make sense. So if it's a stressor that you said this is, what makes a community overburdened, then this is also something that you could then reduce here. And you know, I struggle with this piece too, this compelling public interest piece, because it is so very important, really to the heart of this rulemaking. And, you know, I do have some concerns about making the definition too narrow, because sometimes flexibility is helpful for the future if there's unforeseen circumstances like this. You know, past year we had COVID, which we never expected, and, you know, so we have to have, you know, some thought about how to be somewhat flexible. But it's so important that when we talk about compelling public interest, that we are talking about that host community, and that host community is on board with that. And also, to the point that the other folks have made on here, is that it's not just a politician or elected official who is the community. It's the people who live and reside in that community that are the community. So, you know, I am personally struggling with, like, what would make a good fit for that, because, you know, just having a letter of support from an elected official doesn't necessarily mean, you know, that it's supported by the community and in the community's best interest. So I would defer to the others on this call for that.
Thank you, Elizabeth.
Thank you.
All right. Well, I think we've gotten to the point that people would like us to get to. Let's talk about how we accurately gauge the input and the positions of the community when we're considering public interest. We can go to the last slide. This is our last substantive slide. We'll leave the rest of the time for questions to the extent folks have additional questions or comments they'd like to make. So I think this really dovetails into several questions that we've heard already, and it's something that is extremely high on the mind of the department as we're trying to figure out how we set up this rulemaking. And really the question is, how do we consider the interest of the individuals in that host overburdened community in a proposed project when assessing compelling public interest? You know, and we get into questions of, you know, how do we assess community concurrence, for lack of a better word, if that project seeks to meet a compelling public interest, and how can we really assure accuracy in that assessment? And, you know, I think, you know, people have talked about, you know, elected officials and other things. I mean, I think when we drill down into an assessment of the interest of the individuals in an overburdened community, that is a different conversation than the assessment of interest from the municipality or its governing body. And I think we're well aware that there are significant differences there, and we are looking for feedback and input in how we most appropriately target the individuals that we want to hear from, and how we, you know, should really just, you know, how we should be approaching that. And to the extent folks have thoughts and input on that, we really would love to hear from you on this particular topic now.
Right. Kartik Raj, the floor is yours.
Thank you. When it comes to sort of the public participation, engaging the community's point of view on whether there's a compelling public interest, I think there are two very important steps DEP can take on that front. First, DEP has the authority under the statute to require facility applicants to include any information deemed appropriate in their application for a new facility. And so obviously here, DEP should require the applicant to state in their application whether they plan to seek a compelling public interest determination from DEP, and state the grounds for what they think is a compelling public interest. The public notices that go out to community members to invite their participation in the public comment and public hearing processes should explicitly highlight what the facility applicant claims is a compelling public interest in this case. So community members are very clear about what it is being claimed on their behalf, essentially, in terms of what that interest is. Secondly, I think DEP must be very clear that they will only make any determinations of a compelling public interest based on information that is publicly available in the record of the application process and the public hearing and public comment process under the law, including the environmental justice impact statement. Thank you.
Thank you, and certainly agree with both of those points.
Melissa Miles.
Hello. Now, someone may have said this already, but for this slide here, I think this again gets a little bit tricky, where it says if the community concurs with a project that seeks to provide environmental or public health benefits, is that sufficient to establish compelling public interest? And I want to unequate, public health benefits from compelling public interest. They're not equal. They're not the same. The compelling public interest comes before there's any it should come before, according to the law, any conversation about benefits, whether they be environmental or health benefits. I think again that's falling into the category of, if it's deemed to be a stress, have those stressors, but it is has a compelling public interest, that then we look at the environmental or public health benefits that have to be provided. So, I think that this is, again, it's a slippery slope, because like folks have said, it allows industry then to buy communities with promises of benefits, even though their facility itself may be toxic or may not actually fit a definition itself of what is a compelling benefit. They can, or compelling interest, they can make themselves somehow into a compelling public interest. And I don't think that should not be the case. Not that I just don't think it's, according to the law, it shouldn't be the case that they can, somehow, get in as a compelling public interest because of benefits. It should be because of the facility itself and what it's going to provide, or what it's going to do, that we determine whether or not it's a compelling public interest. So, for example, someone may have already talked about, I don't think this would come up for a permit necessarily, but like say the dewatering facility that's going to be in Newark, that's going to be treating the sediment from the Passaic River, which is a Superfund site, right? So that sediment to be treated, so that, has to go somewhere. Now, the community, through the Passaic River CAG has been for years meeting to talk about the cleanup of the river. That, has agreed that they didn't want their toxic waste going to some other community, and that it should be treated in that community, right? So that's not something coming from the outside. It's something that's already gone through a process, been vetted by the community. And even though it may, it might be a facility, that to me, and, in conversations I've had with other advocates, would be something like a compelling public interest, or something, like a municipal level composting, not regional or not a huge one, but municipal level composting, which would work to get waste out of the waste stream and not have it being burned. These are the types of industries that may be themselves already compelling public interest, but what we don't want to see is something that, really is not desirable. But then the industry says, okay, we'll bring jobs, or we'll bring, and sort of dangle these benefits like carrots, even though they shouldn't even be in consideration. So again, I just want to kind of detach these two pieces and make sure that they sequentially, are coming in the order that they're supposed to.
Thank you, Melissa.
Thank you. Dr. Sheets?
Yes, well, so Melissa said it, right? But this is a tough one for EJ folks. That's why none of us rush to the mic right away, right? Because we certainly want a whole lot of community input, and we want to know what the community thinks, but you don't want to turn this law into a referendum. You know, that's not what this law is. It's not a referendum on what facilities should be cited in the community. And that's what you turn into if you allow to go community by community and let the community decide what is or is not a compelling interest. And just like Melissa said, that's going to be a disaster because people with much more resources than EJ groups or community groups are going to come in and have a much heavier influence that I think most of us would want them to have. And let me just make this analogy for you. And you would be ignoring the law like Melissa says, but yeah, let me make this analogy. For example, if a facility comes to a community that's going to emit a lot of particulate matter air pollution, but it's claiming that it has benefits, you wouldn't go to the community and say, well, we have a federal standard around particulate matter air pollution, but this facility says it's going to deliver a lot of benefits. So do you want to forego that standard for this facility? That's not a question we put up to the community, right? The law has been put in place and we have to follow the law, and there are good reasons, to have the law in place. But I can see how it would be appealing to put the compelling public interest part up for, complete community approval. But again, that would probably eviscerate the law.
Thank you, Nikki. I want to be in any of these scenarios that we've been talking about. In no way are we talking about waiving any sort of federal or state standards or being above those. I think what we were kind of talking about is a situation where we've asked facilities essentially in large part to exceed those standards, but because of existing stressor levels, they cannot ensure that they're not contributing to a stressor level that is already disproportionate. And what do you do in that situation? But never would we be conceiving of a situation where someone is saying, I'm going to do something else as a pass to exceed a federal standard. Not in any way.
Yeah, I'm understood, Sean. I was just trying to make maybe a poor analogy.
Okay, all right. I don't want to make sure that I'm not. Because that's.
I'm just analogizing. It would almost be like that if you allow compelling public interest to be put up to a vote by the community each time.
Okay, I got you, and that's fair. Thank you, Dr. Sheets.
Thank you, Marcus Sibley.
Thanks again. I just had a quick point as I think about other entities when it comes to like ordinances. I think that comes to mind is like the CCR, Civilian Complaint Review Board, and within the ordinance they have that specific long-standing organizations are written into the ordinance so that there's a good chance that you always have the interests of the community in mind, because a part of the ordinance is that you have community members a part of the board. I think about that as I think about this because I'm excited, and I've been excited throughout this process where there have been so many stakeholder meetings and people can air how they feel about the process and give their input, which I think is amazing. I would also like to see if there's a possible way to consider having long-standing organizations that have been in this EJ fight on the other side. So even after the rulemaking process, to be involved with the, of course, it's ultimately DEP's decision when the permits come through. But in addition to the public interest of the town where a facility is coming, if there was like a collective of groups, and many of us which are represented here, that could be also consulted with, and not on a informal basis, but actually a part of the process. Like if we could write it into the policy that these long-standing groups could be a part of the process, because unfortunately, sometimes due to people's access to internet or just the rollout of certain information, sometimes it doesn't get to the people. But if you have the groups that are in the fight automatically receiving, that means even when sometimes the people don't receive it, representatives of the people have received it, and then there's always someone who can speak up for that community. So just an idea I was having while I was sitting here. I just want to throw it out there, see how it sounded to everyone else. Thank you.
Thank you, Mark. It's another excellent point. I think that, we've talked about this internally, but, I think there's, we have some, we're working on ways to even better our outreach, particularly under Olivia's leadership with Rashay Outlaw and Nadia Akbar and Mandy Feudy to continually increase our ability to be in constant communication with longstanding groups, like you're referencing with our environmental justice advocates, to make sure that they have the information that we have on particular applications, so that they can be a voice for themselves and for the people that they represent. So we'd certainly be looking to potentially make that more robust as part of this process, and to ensure that folks have the information so that they can involve themselves and make comments and help us to accurately understand the concerns. And we also have the Environmental Justice Advisory Committee, which Olivia can talk about as well.
Yes, we do have an existing Environmental Justice Advisory Council. We have slots for 18 members as a part of that board, with representation from citizens and stakeholder groups from around the state. And I think if you're already familiar with this, I apologize for putting this out there for you, but I'll just share it with everyone else for their awareness. You can find some specifics about our Environmental Justice Advisory Council on our Office of Environmental Justice website. And certainly we're open to go further than that. So if you peruse that and you still have additional ideas for us, we are entirely open to them. So the website for our Office of Environmental Justice is nj.gov/DEP/EJ. And from there, you'll find a link that will show you some of the members of our Environmental Justice Advisory Council. And I will note there are a number of them who are on the call this evening as well.
And per usual, Olivia, your wonderful staff, and Nadia has already put the link into the chat, so folks can go directly there if they weren't able to copy all the wwws while you were going through it. So try to make it as easy as possible for folks.
Absolutely. Thank you. And thank you, Marcus. So our next is Ray Nichols.
Thank you again. I had 16 years experience working with the Freshwater Wetlands Protection Act, and I'm using that as some of my basis for experience how this new law should be implemented. Under the individual permit provisions requirements, there needs to be an alternatives analysis. And it seems to me, if an entity is proposing something in the public interest and purports to have a compelling public interest, then the community ought to know what the alternatives are. I used the example before of a pump station instead of a sewage treatment plant. It could be, could the facility purpose be met at a location outside of any OBC? For example, a transfer station does not need to be in an OBC, even if it's collecting the solid waste from the OBC. So there needs to be off-site considerations outside of any OBC. It doesn't make any sense in a city like Jersey City, where there are probably a number of overburdened communities, to move a proposed compelling public interest facility from one overburdened community to another overburdened community. And it also needs to consider land that is not currently owned by the applicant. There may be land available nearby, but the applicant doesn't own it, but it might be available. And last but not least, sometimes when things are in the public interest, the proposers like to cite economics, it's got to be the least expensive solution. Well, one of the reasons overburdened communities are overburdened today is because people were seeking least expensive solutions for so long. And so I don't think that least cost should be a determining factor. And lastly, about to make application materials more available, I would recommend, and it's been done in the past for pipelines, have the applicant provide a paper copy of everything to each local library, public library. And then anybody can go into the library and look at it and see it. Libraries hopefully have longer hours than municipal buildings. Thank you.
Thank you, Ray.
Thank you. Julia Summers?
Yes, one last thing. I've heard a lot of talk about benefits being offered to communities. We see this happening all over the place. That doesn't mean they're realistic. I don't know if the law provides the department the opportunity to do this, but certainly municipalities can do this. Maybe it is possible for there to be a bond attached to providing those benefits. And once those benefits have actually been provided, then the bond could be released. I'm sorry, but I see extraordinary benefits being offered to highlight the opportunities for communities to do certain things. And they're totally unrealistic. And if there were a bond attached, if there were consequences, maybe only realistic benefits would be offered, and we would really know what the opportunity was. So I don't know if that is, I don't know if Sean can say if that is a possibility under, you know, what the law allows, but if it was, I would strongly recommend that bonds be attached to the benefits being offered communities. Thanks.
Thank you. We certainly have some experience with bonding to guarantee performance in certain areas, and that's something we'll definitely consider if it's appropriate under what we ultimately land on. Thank you. I mean, I certainly like the idea of both deterrent and guaranteeing performance if there are benefits to be provided.
Thank you. Next, Maria.
Hey, so what I'm going to say may be controversial. I haven't cleared it with my colleagues. But I'm not actually for you writing in specific community organizations. I understand why you need trusted messengers. The relationships between authentic community members and government's been broken, right? It's like completely broken, and this law is a baby step in the long journey. We need to repair that, to feel like the Department of Environmental Protections actually protects us, right? So that's my disclaimer of I guess, because I think about even at ICC, like I might not always be at ICC. I don't know as an organization its trajectory. It's held out for 50 years, so I feel pretty good about it, right? But I worry about individual organizations becoming corrupted. I worry about different communities where you don't have an ICC. Like as ICC, I do feel like a burden to be at so many tables just to represent our community. But I think that's unsustainable in the long term, right? Like we can't just depend on community organizations to step in the place of what should be authentic democracy. And so I guess I'm not vetoing it. Like it makes sense as a stopgap, but I would like DEP, and maybe like this is part of this process, but it's more expansive. And Olivia, I want to congratulate you because I feel like I've heard you talk about this publicly, right? Like what about organizations that don't have a community group? Because that's where my worries go of like, organizations that don't have a community group or that have a community group that hasn't been listened to, which I think about the Lene Lape in Ringwood, right? Like they've been trying to make their case before the DEP, and that's been unsuccessful. And I'm hoping that that starts changing. But there are groups that maybe don't have the political power that we've been able to gain with ICC, right? Like I don't want that to be the standard because I recognize that's unfair. Not everyone has that. So I would like to see a situation where the applicant, more burden gets put on them for community outreach or to pay for it. Maybe the DEP does it, but it collects a fee from the applicant, right? To be able to put mass mailers. Because even if we put in the library, like I only by working here that I learned that you can go to the library, look up the permit, but then the permit's totally unreadable, even to me after I've been in this work, right? It's unreadable. And that's where we keep pushing that the DEP figure out a public education strategy so that this becomes like, I think what you've done with this stakeholder engagement's been beautiful. I congratulate you for that. You know, like we see more engagement and people actually being able to talk, or even if they're just listening, I feel like the growth is happening. And I want to see that in terms of how does, as a department, you become as recognizable as the Parks and Recreation Department, you know, like where people can see it, feel it, and it becomes tangible to them. And, you know, because I really dream of a future where ICCs are irrelevant and the people can have a relationship with the government offices directly. And then there is no question about who the community is, you know, like, and I know I'm being maybe a little too optimistic. We're not there yet. And in the stand, you know, you can rely on obviously historic environmental justice organizations, but I just want to make sure that I state that our thinking should be broader so that we can have more direct connections. You know, community is about relationships. And we need, as the DEP and other departments, I think you're leading the way, and it doesn't stop there. I'm happy for the work of the Interagency Council, but I wanted to continue, right, of how does departments build relationship directly with people on the ground. And I really do hope that there's a day where we're relevant and you don't have to have a distinguishing point between advocates, organizations, and people. Like you actually have relationships with the people, and when you ask them questions, they answer. And to that point, the only, I guess, substantial feedback here is make sure that everything the applicants put out, I think it should be fact checked by DEP. I would like to see that be included. You can't just have the applicants doing community outreach on their own, because that becomes a PR machine that they do. You know, it's just whatever they want to say. And so I think the DEP should take some responsibility to fact checking whatever the applicant is putting out to the community, you know, and we develop a partnership and it goes on that way. Thank you.
Thank you, Maria. As usual, you hit the points right on the head. I mean, I think part of what we're struggling with and why we're asking this question is we know we can't take for granted the work that ICC does and that exists everywhere. You know, it's certainly, you know, a situation in the Ironbound. We know who to call to try to gauge what the community's position is and how we can best serve the needs of those members. But we know that that's not everywhere, and we're really trying to figure out how we best address that. Burden on this is most certainly on the applicant. You know, this is work that the applicant needs to do that outreach to get with those groups. We're just trying to figure out, you know, how we come up with the appropriate standards and the appropriate level of direction so that we can enforce that outreach, quite frankly, and then what we can do on the back end as the department to try to amplify and assist with that, you know, to ensure that it's being done correctly. So I think you really hit on, you know, several good points, and I would just lastly say it might not seem like it when you see me here every month, but I am also optimistic for our future, and I share your hope for what this looks like as we continue to better ourselves as a society. So I'd like to echo that, even though it's not really on point and not what a lawyer would say, but that's okay.
Thank you, Maria, and thank you, Sean. Next is Ray Nichols.
Thank you again. I'm trying to share my knowledge based upon years of experience. I live in a small municipality, and we have one municipal engineer to do all community development, and I can't do it by himself. So anytime an applicant comes to the planning board with an application that, and I'm going to use the example, will have generate a significant amount of traffic, the applicant is required to post money to pay for the township to hire their own independent transportation engineer. to evaluate the applicant's transportation engineer's reports. And I believe this would be one way, especially given the highly technical nature of the kinds of projects that DEP is being asked to look at. And I know that a lot of your most experienced staff over the years have retired and not been replaced. I have an engineer friend who used to work in stream encroachment permits, and every time she found a mistake in an applicant, particular engineer's report and flagged it, the next application she saw from that engineer didn't have the same mistake. He learned, but there was another mistake, another assumption made that was not valid somewhere else in his analysis. And that's only learned by experience. And so DEP needs to retain its experienced staff, and where it doesn't have sufficiently experienced staff to review these applications in adequate detail, it should make it incumbent upon the applicant to provide funds to enable either the department or the community where the facility is proposed to hire their own expertise. Thank you.
Thank you, Rick. That's certainly, that's certainly a concept that's worth further consideration on our side. Not something we're familiar with in particular areas, maybe applicable here. Right. I think we may have reached the end, Olivia. If that is the case, I would just like to say thank you to everyone. I know that we had to touch on some topics that folks were not crazy about, and I understand that. I appreciate the candor. I appreciate the openness of conversation, and I, above all else, appreciate the feedback, which is all extremely helpful for us as we go back to deliberate on how best to approach this, particularly these two issues. So thank you all again. Olivia, I'll leave that to you.
Yes, I want to reiterate Sean's thanks to everyone for your remarkable level of just consideration and deliberation of these topics that we discussed this evening. And just your graciousness and insights will be deeply valuable for us as we're going forward to begin drafting rules in the coming months. And before we departed, I wanted to just underscore something that Marcus Sibley said. He was talking about the work that we're doing here in New Jersey, getting recognition. And to just complement that stream of thought, that idea, I just wanted to share with everyone that New Jersey is truly privileged to have two people who were just appointed to the White House Environmental Justice Advisory Council. And I just wanted to publicly recognize them here. And that is Maria Lopez Nunez, as well as Dr. Nikki Sheets. So if we can just drop that link in the chat for everyone to see that the White House has selected two people from New Jersey to be a part of that distinguished board. We certainly have a lot to look forward to, and it certainly sets the bar high for us, not only in our state, but also to set an example to our nation. So I thank you all again for coming out and participating in this fourth stakeholder meeting. Don't forget to check our website for the presentation, the recording, and a survey. And beyond that, we look forward to seeing you next month.
Cheers to that news. Thank you, Olivia.
Absolutely. Thank you. And
thank you, Olivia and Sean. You're doing a marvelous job.
Thank you. Thank you, everybody.
Thank you.
Have a wonderful evening all.